Okay, well, I think we're going to go ahead and get started. My name is Rhonda Heights. I am a Parent Resource Coordinator at the Munroe-Meyer Institute in Omaha, Nebraska, on the UNMC campus. One of the things that our program does is helps parents and families get connected to information, resources, services that might be helpful to them if they have a child with special health care needs or a developmental disability or disabilities in general. The purpose of this information series is to help share information, kind of get it out broadly to parents, families, caregivers, so that they have a better understanding of what types of things to look for, particularly in regards to transition. So that's why we have Marla Fischer-Lempke with us this evening to talk about guardianship. So I'm going to go ahead and share my screen here. Just give you a little bit of information before we have Marla take the stage. Can you all see my screen okay? Okay, great. So again, as I said, my name is Rhonda Heights. I am a Parent Resource Coordinator at MMI. We really wanted to find a way to reach out to families and find ways that we could just get that information out. That was, and I forgot to mention this, I'm actually a parent as well of a child with special needs. And so these were things that I thought would be really helpful to get out to families, just to have more information and more tools in their toolbox. That's kind of what the purpose of our entire program is, the Family Care Enhancement Program. And we're just there to kind of help build that bridge for families. A few housekeeping items for tonight. We will have you submit questions via the chat. If you are not familiar, I did send out some kind of examples and some information on how to utilize the chat for questions from Marla. Reason for that being is that we have a number of people that are participating from across the state, and so it can get kind of difficult to field questions when we're all answering and participating. So everyone has been muted for this presentation, so just know that's kind of the way that it makes it more streamlined for questions. We are recording this. Our hopes is that we will then be able to have this available for later viewing, either for other people or if someone who did participate wanted to go back and hear something like, you kind of remember, I think she said something about that, but I don't remember exactly what it was. It would be an opportunity then to go back and review that information. At the end of the session tonight, there will be a very, very brief poll that will show up on your screen as part of the Zoom meeting as well. There's just, I think, like 3 or 4 questions. If you could just take a couple of minutes to please answer that and provide some feedback as to whether this session was helpful, if there's other things that we could do differently, better. We're really kind of trying to tweak this to make sure that we're really hitting the nail on the head as to what families need and making it accessible for them, and covering the topics that are important for families as well. So please help us with that so that we can make this the best presentation and the best series to really cover the things that you as families need that information on. The next session that we have, just real quick, is we're planning for May 26th with a representative, and we're still kind of working on the details of this, but from the Nebraska Department of Education to cover transition, and just kind of some more information about like what types of services to expect, maybe talking a little bit about things in regards to COVID and how that affects education services as well. So look for that. I've been sending out information to anyone that's on our list, but you also have that information in the handouts that I sent to you earlier today as well. So tonight, we are so very fortunate to have Marla Fischer-Lempke from the Office of Public Guardian to talk to us about guardianship and some of the alternatives and maybe things that people don't typically think of as alternatives to guardianship. It tends to be something we kind of tend to think it's either black or white. It's either you have it or you don't, when actually there's a number of different things and ways to go about helping support your family member or your adult child make those decisions but and it varies for everybody, which is going to be the best tool for them. So I'm going to let Marla go ahead and take away. I just want to make sure you all have my contact information. If you have any questions, please give me a call. I'm not there right now, working currently, but if you leave a message there, I get it in my email. So you absolutely, I can get back to you or shoot me an email as well. I am working from home currently. So with that, we will go ahead and have Marla get started.
Okay, thanks, Rhonda, and thank you for having me. I did this presentation, I have tweaked it just a little bit, but I did get the opportunity to do it in person back in September, and I am thrilled to be asked again to present. I really enjoyed my time, had a lot of good audience participation, and that's ideally what I'm looking for in this format as well. I know it can be a little bit more difficult having to use a chat feature, but Jennifer Hansen is graciously monitoring that for us. And Jennifer, if you don't mind, if something seems relevant that comes up, please feel free to interrupt me and ask. I kind of prefer this be more of a dialogue than me just talking at people, and then if you're like me at all, your question goes in your mind and then out, and you have no idea what it was you were going to ask until it's too late. Although I will say it's not too late. I do have my contact information at the end of the presentation, where you can certainly get a hold of me as well if you have follow-up questions that you thought of that you didn't get a chance to ask, or that you just happen to think of later. So I'm just gonna give you a little bit of information about me, then I'm going to talk a little bit about the Office of Public Guardian, and then finally the information that you came for, which is about guardianships and alternatives to guardianships. So just quickly a little bit of information about me. I have been I'm the Deputy Director for the Office of Public Guardian and have been in this position for about 5.5 years now. I was a part of the office when it started, and before we started even taking guardianship cases. We were just kind of putting it all together, hiring people, figuring out what we wanted our processes to look like. So it's been a great opportunity for me to be able to be a part of building this office from the ground up. And we have definitely grown since I started. So that's been a lot of fun to watch. Before I was at the Office of Public Guardian, I worked for a little bit with the State Ombudsman's Office, which is a part of the legislature. So we would get contacts from the public about different systems issues that people were having with navigating different state systems. And I thoroughly enjoyed that position. Prior to that, I was the executive director for the ARC of Nebraska for 5 years. And prior to that, I was with Disability Rights of Nebraska as an attorney for 4 years. So I have had a lot of experience with people with disabilities in my career. And then on a personal level, I have a younger sister who has Down syndrome, and I am now also her guardian. Our mom passed away about 1.5 years ago. So now I am experiencing guardianship from, kind of just a family member, sister role on the outside and professionally to actually being a guardian. So I do have some personal experience as well. So first, I did kind of give an overview, I guess, a little bit of our topics of conversation, but if we could just flip to that next slide. As I mentioned, I'll talk a little bit about the Nebraska Office of Public Guardian. Then I'll move into what's called surrogate decision making in Nebraska, from least to most restrictive options. I want to talk about model practice in decision making. So within whatever role you choose is a good fit for you and your family, or a person that you know. We can talk about how to go about making decisions for people. And then I also want to talk about capacity and how that looks different at different times, and we can kind of analyze that a little bit. And then I do have a set time for questions at the end, but again, I encourage you to ask questions throughout as those come up for you. First, a little bit about the Office of Public Guardian. Nebraska was actually, I think at the time we adopted legislation, we were the last state to adopt legislation for an Office of Public Guardian. We are one of 4 offices of public guardian that are housed in the judicial branch, and most offices of public guardian are a part of the executive branch, or they contract with states. They're maybe a nonprofit, and that's their form. But we are a part of the judicial branch. We are guardians and conservators of last resort for adults who have no one else to serve as a guardian or conservator for them. So they have, no family members, no friends, nobody who is willing to step up into that role for them. We are charged with safeguarding individual rights by supporting people in the least restrictive manner. We're also charged with modeling the highest standard of practice for guardians and conservators, and that's information that I, in part, hope to convey to you a little bit tonight. And then we are charged with developing a uniform reporting and data collection strategy where we report to the Supreme Court the number of cases that we have each year, as well as the legislature. And we develop a written report that's shared both in hard copy and then also on our website in electronic format. We also are a public resource, so we do presentations when we're invited to do so, such as this. But we also are a public resource to private guardians and conservators. We're charged with providing training and education to all people in Nebraska who become guardians and conservators in the state. We have 17 associate public guardians across the state who provide those trainings on a monthly basis within their own geographic areas. And then we recruit members of the public and family members to serve as guardians for the people that we serve. I mean, I mentioned that we are to be guardians of last resort for people who have no one else. So as we're working with people, we try very hard to find out who else is in their life who might be interested in assuming that role later on. Ideally, in order to keep being able to serve people, we need to, we have a limited number of people who we can serve. Right now, in fact, we have a bit of a waiting list. So as we're able to locate people or less restrictive options for people, that's the route we go in order to kind of free up a spot to then serve somebody else. And we also then like to locate what you call successor guardians or conservators to help us serve the individuals that we're currently serving if we can. This is a beautiful map of our different service areas. I can kind of tell you what, out of the 17 associate public guardians, we have one person who handles the Panhandle, one person who serves that yellow area and is central, her office is in North Platte, one person who serves the Kearney Green area. We have one person who serves kind of more of the Grand Island area and some of the north and eastern counties in that whitish area. And then another person who serves the Hastings and the other counties to the west and then the southern portion of that area. We have one public guardian who serves the Norfolk area in blue. We have, and then just the blue area. We have 4 public guardians who serve in the Lincoln, the Lancaster County areas, and sort of the blue off to the west of Lancaster, and then Gage County. And then we have 7 public guardians in Omaha who serve the pinkish, the coral, and then the light blue of the southeastern portion of the state. So that the people who are outside of Lincoln and Omaha always office from home, but now the rest of us are getting to do that for a while as well. So that has been interesting. But I just wanted to share with you kind of the way our office is split up and how we serve the individuals on our caseloads. And then if you want more information about us, I should mention that we're not really a program that is, easy to access, again, because we are a last resort, but we are easy in the fact that we do provide training for guardians and conservators, private guardians and conservators. And our education and outreach person, Chelsea Richardson, has just recently, under the branch, launched a Facebook page for us, and she's also in the process of doing many amazing things in helping to kind of spread the word about what guardianship is, what other options aside from guardianship can be, and then providing different resources that we often might get questions about, that guardians are curious about as they're working with a friend, a family member, whomever it is that they're trying to help with decision making. One of the biggest tools I used in creating this presentation is the Surrogate Decision Making in Nebraska resource. And this is a Department of Health and Human Services state aging excuse me, resource. And I provided the link to that. Again, a lot of the different types of decision making that I'm going to mention stem from this, as does some of the language, and I've cited the pages of where I got that language on the slides. But it's just very, very brief within the verbiage on the slides. So if you get a chance to access that link, I would highly encourage you to do so for a little bit more in-depth for descriptions in writing. So the different types of surrogate decision-making that we'll talk about are advanced directives, representative payees, protective payees, Veterans Administration fiduciaries, powers of attorney, durable powers of attorney, conservatorship, limited guardianship with or without conservatorship, full guardianship and conservatorship, and then we also talked about the Office of Public Guardian. But I mentioned it again just because I wanted to show you kind of a listing of the options that are available from least to most restrictive. So first, some information about advanced directives. An advanced directive is actually a document that allows a person to give instructions about future medical care if that person is unable to participate in their own healthcare decisions because of serious illness or incapacity. The most common types of advanced directives are living wills, powers of attorney for healthcare, code, no code orders. So like those are such as like do not resuscitate orders. And of course, it's best to make an advanced directive in writing. Some people might tell their friend, well, if I ever end up where I can't, speak for myself and, what kinds of healthcare decisions I'd want, make sure that they do X, Y, or Z. Well, that's great to tell someone, but it's best to do it in writing, because usually when we give oral directions, that's might not be clear to the person receiving those. Maybe they're not complete. So it's most beneficial to have those things in writing. I'll give you an example, and this also kind of goes with decision making and getting to know people so that you can make good decisions for them. But we talk with each one of our wards about, different decisions that are important to them and that they want to make in their life. And we also talk with them about advanced directives, so that to the extent that they're able to participate in that conversation, we can honor their wishes. So you can imagine, though, that those conversations can take many different forms. So, we'll have one person who has told one of our guardians, well, I just don't want anything. Well, and then we try to get at, okay, well, what does that mean to you? So that we're being very clear. Well, what is not anything? Oh, well, then we find out that, oh, he would like CPR, but he doesn't want to be tube fed later or something like that. So, again, that's why it's always good to put it in writing. And even if a person hasn't put it in writing ahead of time as an advanced directive, it's good after having those conversations to get it in writing as well. And I'll give you a resource for that in a little bit here too. The next advanced directive is a living will. And a living will is a written statement that describes the type of care a person wants to receive in the event that they have a terminal illness. And these are not my words, but they're medical words, where a person is in a persistent vegetative state. So it gives healthcare providers and loved ones guidance when the person isn't able to do it himself or herself. And it's important to understand that living wills cannot be used for any other type of situation. So they're very specific. And a living will is authorized under Nebraska law by the Rights of the Terminally Ill Act, which allows one person to make a declaration of their intent in writing about the type of medical treatment that they want to receive, again, in case they're terminally ill, or, again, medical term, in a persistent vegetative state.
Marla, we had a question come in.
Yes.
The participant said, we took an example of a power of attorney for healthcare for Nebraska off the web. Will this hold up, or does it need to be done by an attorney? It is notarized. Also the same question for a living will. It's notarized, but does those need to be produced by an attorney?
That's a good question. They don't have to be produced by an attorney, but if you want to make sure that what you have written in those corresponds with what your intention is, it wouldn't be a bad idea to run it by an attorney, just because he or she might be able to help you refine some language that might be different from what you found on the web. And there's lots and lots of things on the web, so you kind of have to be careful with that. Though I will say that it's good information to have that gives some good guidance, but you just want to be very clear that the guidance you think you're giving is truly that. So it truly represents your wishes. Another item, and this is something new that I had put in, is surrogate decision making in the absence of anything. So let's say you don't have any kind of advanced directive. Well, in 2017, the legislature passed the Healthcare Surrogacy Act in Nebraska. And this is an act that allows a surrogate, or someone who's designated, to make healthcare decisions for an adult patient when that person is determined by their primary physician to lack capacity and there's no agent or guardian who's been appointed. So this means that there's no healthcare power of attorney, there's no living will, there's no code order, there's just nothing. So an adult patient can then designate someone by personally informing the supervising healthcare provider. Otherwise, if the person isn't able to make their wishes known, isn't able to talk about who they would want to help make decisions for them at a time when they need someone else to help, the order of priority is as follows in Nebraska. So it's the person's spouse, unless they are legally separated, their adult child, a parent, an adult sibling, or a person who's called an adult familiar, who would be non-relative, who shows special care and concern. So that could be, you know, a close friend, for example. It can become difficult, however, if people of equal priority are designated and they don't agree, or if nobody who's listed above is willing or able to act. So let's say you have two adult siblings who may disagree about what it is that should happen for your care. One, you know, maybe you've shared with one of them what you wanted, but you didn't tell the other, and maybe those ideas conflict very much with how everyone in the family was raised. Those are sticky situations that you would want to avoid if at all possible. So again, getting things down in writing ahead of time is the best idea. But if those things happen, that's where you know, lawsuits kind of happen, and things go directions that you don't want them to go. So while this is in place for times when there is nothing and it helps provide a little bit of guidance, it's not the best idea. One thing that we encourage people to take a look at is, as an advanced directive, is a healthcare power of attorney. And a power of attorney for healthcare is one in which a person who's called the principal authorizes another person that's called the agent to make healthcare decisions about him or her. And so it can be used in a variety of situations, and it's not limited, you know, like a living will where the person has to have a terminal illness or be in a persistent vegetative state. So it could be a situation where you need help when you go to the doctor and you want somebody there who just makes decisions for you because you just get overwhelmed with all the information and you just can't handle it. That might be a situation where that would be helpful. But if you're incapacitated in some way and unable to communicate what your decisions would be, this is a document that allows someone to act in your behalf just for healthcare decisions. So if a power of attorney for healthcare is used where a person does have a terminal illness or is in a persistent vegetative state, the power of attorney for healthcare must clearly state the wishes of the principal. And if the power of attorney for healthcare, well, the Power of Attorney for Healthcare Act specifically authorizes the use of a durable healthcare power of attorney in Nebraska. So that means that even when you become incapacitated, this thing stays in place. It keeps going until you die. What's important to note about healthcare powers of attorney is that, oh, could you back up just a second? Sorry, Rhonda. Is that the principal, so the person who made the healthcare power of attorney, does not lose the authority to make their own healthcare decisions just because they have this thing in existence. So they really only spring into effect when the principal, the person who created the document, is unable or doesn't wish to make those healthcare decisions. They're unable to communicate them, or they simply, as I gave the example before, you know, they get overwhelmed and they really want somebody else who's there who can help them make those decisions. But otherwise, just because someone's named under a healthcare power of attorney, let's say I name my husband under a healthcare power of attorney, I still have the authority to act on my behalf unless I become incapacitated or unless I state that I don't want to deal with these decisions. I need you to be there to be my voice in this area. Okay, now we're ready. Any questions about the healthcare powers of attorney, Jennifer? Or anything we've talked about so far?
One just came in. Can a medical power of attorney have access to medical records?
Most likely, if they're going to be making healthcare decisions, I guess depending on what that is, if the medical records are relevant to the decision that they're going to be making, I would think yes, that they would need to have access to those. Generally, though, if it's just to have records, that I don't know why that would be necessary. It might be harder to get them.
That was the only question so far.
Okay, thanks. Okay, so we'll move on to the advanced directives of do not resuscitate or DNR orders. So called CPR, cardiopulmonary resuscitation, is routinely attempted if a person suddenly becomes unresponsive. And, that involves forceful chest compressions and electrical stimulation to the heart if needed. So generally the person is asked upon admission to a hospital or a care facility whether or not they would like CPR if their medical situation should warrant it in the future. So the person should discuss with their doctor whether a DNR order would be appropriate. And then if the doctor signs a DNR order, and puts the order in the chart, then CPR won't be done. And this, for a lot of people who are transitioning into adulthood, I guess it depends on what their situation is, but a lot of people probably aren't thinking about this. And I just mention it because sometimes it is a consideration for people who, who may stop breathing and so on, and do need to consider whether or not this is, a course of action that is appropriate for them. We often use this in our situations where, and I don't say use it as in put it into place, but as a consideration for people who are older and who have chronic conditions where they, this is a very much a likelihood that this is a question that's going to come up for them. So, so that's why I put this in here, though. I will say that sometimes we have been asked, when we have people who have very serious medical conditions who we've been encouraged to change their code status to a DNR who are full code. And we know that this person doesn't, clearly knows what that means for them if they were to receive CPR and wants to have CPR. And so we object to changing their code status, even though that might be something that the doctor is recommending. If we have discussions with our ward and they can clearly demonstrate that this is something that they would want CPR performed, and they understand what that means, and if they want to change their code status to a DNR and they understand what that means, it works both directions. So this is not something that you want to take lightly, obviously. So you want to make sure that if a person is telling you this, that they want full code, or especially if they want a DNR, that they fully understand what they're talking about. A great resource, again, this is something new that I've added to this presentation, and something that a lot of our associate public guardians use, is something is from the 5 Wishes organization. And this is an organization, I've provided the link, that has a lot of good resources for starting conversations about healthcare treatment and what people do and don't want, and how do you convey that information in writing. And also, it talks about pretty much the whole spectrum of life for different things that you would want to have a conversation about in terms of healthcare decisions for people. So I believe they have resources on there that you can order, but I know they have other resources and information on there as well that is just helpful to consider. And the items that are available for purchase, I think, are often as low as like $5 a piece. So they do have some very useful pieces of information to get usually an uncomfortable conversation started. So I'd encourage anyone to go to that site. So next we'll move on to, we're moving away from advanced directives into representative payees. And this is a person who's appointed by the Social Security Administration to receive and manage benefits administered through the Social Security Administration. And a representative payee can be considered when the person receiving benefits, so anybody who receives supplemental security insurance, which is called SSI, or supplemental security disability income, which is called SSDI, or even if they just receive regular retirement Social Security as an SSA benefit. Any of those people who receive those are called beneficiaries under Social Security terminology. And anybody who manages those benefits for them who is appointed by Social Security is called their representative payee. So Social Security is in charge of identifying whether or not this person is in need of a representative payee. And the threshold for that is fairly low, in that a person identifies, or maybe someone kind of identifies on their behalf, that they're not able to manage that Social Security income that comes in for them. So in that case, Social Security, just like about any other organization, has a list of people that they prioritize to decide whether or not they can be appointed as the person's representative payee. So these are the factors that go into what Social Security looks at. So first of all, the person has to be alleged to be incompetent, or there's evidence that the person, the beneficiary, can't manage his or her benefits. They need to be found as disoriented, and again, this is Social Security language, unable to communicate with others, unable to reason or have impaired judgment. They're physically dependent on others to cash and pay out their benefit checks, or make decisions regarding the use of those payments, or they're legally incompetent. So we have found that when a person is under guardianship, often Social Security will look to the guardian as somebody of priority to then become that person's representative payee. So in a kind of a similar vein, there's also something called a protective payee, and this is an individual who's assigned by the Nebraska Department of Health and Human Services, or DHHS, to receive public assistance payments on behalf of another person. And so it's a similar relationship, except now we're talking about state benefits instead of Social Security benefits. And the protective payee has not only a supervisory role of those funds, but also a teaching role. And that's really true of Social Security funds as well. Representative payees want to help ensure that, to the extent that they can, that they're teaching people how to manage their benefits and expend the funds for things that they need. So the same is true under a protected payee relationship. And just some state cash assistance programs in which there might be a protective payee would include things like the Aid to Dependent Children program, which provides financial aid to children and parents or relatives with whom children are living, the state disability program, and the state supplemental program, or you might have heard it called AABD, where people who are 65 years or older, or people who have a disability or are blind, can receive that benefit. We have a number of people that we support who receive Social Security and AABD funds to assist with their living expenses. And so in those cases, we're both representative payee and protective payee for people. And I should mention, in each of those relationships, there are reporting requirements when you assume those roles. So each year you have to report to Social Security how the benefits are spent. Sometimes they'll send out a report that they'll want you to make in terms of whether or not the person's disability is continuing. And then the protective payee, often you'll have to report income and resource income and resources that the person has financially, so that the state can then determine whether or not they're still eligible for those state benefits.
Okay, we've had a question come in, Marla.
Okay.
They're asking, once a payee is designated, is that just for an indefinite amount of time, or can it be for a short term if somebody's designated unable to manage their own finances for just a short term, and then the payee is
Yeah, that it depends on the situation. So first of all, everybody is presumed that they don't need a payee, so they're responsible for their own benefits. So there would have to be shown some sort of incapacity in order for a person not to be able to manage their benefits to get a payee put in place. However, if there's a time where the person does show that, oh, now I understand how this works, and I can use this money to pay my bills and so on, then the representative payee who's been appointed can notify Social Security that this person no longer needs a payee. Social Security, would have to agree with that statement, and then Social Security will then pay the benefits directly to the beneficiary instead of to the payee. And by the way, I shouldn't say pay to. They will pay them. They're always paid to the beneficiary. It's the representative payee who was managing those benefits. So also totally different presentation, but accounting for those benefits is something that people really need to be aware of, and keeping accounts separate from other funds and so on. But that's a whole other issue. So at the federal level, there is something called a Veterans Administration Fiduciary. And so this is for an individual who receives Veterans Administration benefits. And usually these are monetary that would need to be managed, similar to Social Security benefits or state aid benefits. So in that situation, an individual or an entity is appointed by the Veterans Administration to manage those benefits for a veteran who is incompetent, or for a minor who is a dependent of a veteran who is incompetent. And the VA determines that a person is incompetent when he or she lacks mental capacity to conduct or manage their own affairs, including the disbursement of funds. And the duties of a fiduciary include applying the benefits to the needs of the beneficiary and their dependents, protecting the payments from loss or diversion, and then accounting for the receipt and disbursement of the benefits payments upon the demand of the VA. So this is a little bit different. The VA doesn't necessarily look at the same factors that maybe Social Security looks at when they want to appoint a representative payee. So, for example, we have some people who receive Social Security and VA benefits, and while Social Security is fine with us being a representative payee, the VA may have chosen someone else to be the fiduciary for that person and manage those VA benefits. In other cases, we are named as both. So it really just kind of depends on the circumstances of the person and whoever the VA deems appropriate to manage the benefits. There might be somebody of higher priority than us in their eyes that would then manage the benefits. It just depends. Okay, so now we will move on to other powers of attorney. So remember, before I mentioned healthcare powers of attorney, this is more general. So this is a general power of attorney. So it is not limited to just healthcare. It's much broader than that. But like a healthcare power of attorney, it's also a document that authorizes one person to act on another person's behalf. And the terms there are the same, in that the person who creates the power of attorney is called the principal, and the person who acts under the power of attorney is called the agent. And powers of attorney can either be limited or general, depending on however the principal wants to write it. If it's limited, it gives the agent authority to act on the principal's behalf only with regard to very specific matters. So the example that's listed here is you're giving someone authority to spend your money just to maintain your house while you're away. Let's say you go away for the winter and you need somebody to maintain your property while you're gone. So you could list just that in a power of attorney document, naming somebody else to make decisions about maintaining your property. A general power of attorney, though, gives the agent authority to act on the principal's behalf in a wide variety of actions. So the example here is the authority to manage all bank accounts and property. So, you know, maybe you just don't feel like you're good with money, and you don't want to deal with bank accounts, you don't want to deal with maintaining property. It could also, you know, involve, you know, other types of decisions as well, depending on what you have and things that you need to make decisions about. So however you want to write it, whatever you want it to include, it's up to you. So it's as broad or as narrow as you would prefer it to be. There are important limitations to be aware of, that the powers of attorney don't give an agent the power to make decisions against the principal's will. So if I tell you that, let's see, under no circumstances do I want to have, you know, a pool put in my backyard, and you know, a contractor comes by and, you know, talks to me about, oh, wouldn't a pool look good, and your neighbors have a pool and blah blah blah, and I gave you the authority to manage my house while I was gone, and I said no pool, and then finally I come back and, oh my gosh, there's a pool in my yard. Nope, that you didn't have the authority to make that decision. So, and that's an extreme example, but that's what that means. And you have to make decisions that are consistent with what the principal intended when they wrote that document. Powers of attorney don't take away the right to make decisions from the principal. Only a court can take away the right of someone to make decisions. So remember, I talked about that a little bit with the healthcare power of attorney. If I happen to have a healthcare power of attorney, but I'm sitting in front of you and I've named somebody else under that healthcare power of attorney, but I am capable of making decisions for my healthcare and I don't really want anyone else doing that right now, then you're going to need to talk to me, as long as, you know, I'm competent to do so. And you shouldn't be looking to, you know, to somebody else that I've nominated under my healthcare power of attorney. Same thing here. No one should be looking to the agent in your power of attorney document unless for some reason you're unable to make those decisions. And then powers of attorney are no longer effective when the agent knows that the principal has passed away. So anytime anyone passes away, any powers of attorney are done. They are no longer in effect. And then there's something called a durable power of attorney. And this is a power of attorney that lasts beyond disability or incapacity of the principal, and it can be revoked or modified at any time as long as the principal is competent. So let's say I tend to go out of state for the winter, and I have Joe managing my property under a power of attorney. Well, I went out of state this year, and I ended up in a car accident while I was out of state, and now I have experienced a traumatic brain injury, and I'm not able to make decisions right now because I'm recovering from that, and we just don't know what that's going to look like. Well, under a durable power of attorney, it doesn't matter. Joe can continue to make decisions about my property while I'm gone. So a power of, in Nebraska, the law has changed a little bit from what it was, I guess, prior to 2013, I think. But a power of attorney is durable unless it expressly provides that it's terminated by the incapacity of the principal. So a power of attorney doesn't need to say that it's durable. So I just gave the example of how the power of attorney would last if for some reason I became incapacitated. But if I had in there that one, if I become incapacitated, I don't want Joe making my decisions anymore, then that power of attorney is not durable, and it's not going to continue to be in place. Though Joe, of course, probably has to know that I am now experiencing an incapacity. So any decisions he makes before he knows that, it's, you know, he didn't know. So we don't blame Joe in those circumstances, but so those are important things to know. So that goes then back to the question of, should I consult with an attorney about my power of attorney? That's why it might be a good idea to make sure that what your power of attorney, healthcare or otherwise says actually states what you intend for it to say. Was there another question, Jennifer?
No, that was just it. To have the power of attorney document drawn up by an attorney or for it to be legal.
Okay, yeah.
Or binding. Yeah.
Sure. No, so you can, I mean, again, as you may know, there are power of attorney documents online, or sometimes you can pay for things that are sort of templates for you, but the best idea is, and so you can create your own, but even if you do that, you might want to just pay a little bit to an attorney to have it run by their eyes. So again, they can make sure that it says what you are intending for it to say. And there are ways to hire attorneys in a very limited capacity like that, so that you know, if you're trying to avoid a big legal bill, that's one way to do that. So next, we're moving on to the next, and again, we're moving to more restrictive options. So the next option is a conservatorship. And a conservator is an individual or corporation appointed by a court to manage the estate, property, and other business affairs of an individual whom the court has determined is unable to do so for himself or herself. And a number of different people may request a conservator be appointed, and that could be the person who is to be protected, any person who's interested in the property of the person or the welfare of that person, including a parent, guardian, or custodian, or any person who would be adversely affected by the lack of effective management of the protected person's property and property affairs. So that could be so somebody who recognizes that they are not good with, let's say somebody inherits money or something and recognizes that they're not very good with managing funds. They might choose to have somebody be a conservator for them. Or there's somebody who, somebody else who's interested in that person's property. So like, let's say a child is in a car accident and there is a settlement. So the settlement would be managed by, if there are funds in the settlement, they would be managed by a conservator. And then finally, this is kind of a situation if you ask me, but anybody who might be adversely affected by how the property or funds are being managed. So in other words, the third thing is trying to get at anybody who stands to inherit property or funds that are currently being managed by somebody. Might be interested in having a conservator appointed so that those funds aren't wasted and that they'll still inherit something. That's what that provision allows for. So again, this is more restrictive because with all of the other options that we've talked about so far, we haven't had to have court involvement. We haven't had to have attorneys involved necessarily. Here, you don't have to have an attorney involved, but it sure helps when you're trying to navigate in court to have an attorney be the one who files the petition and so on. Again, you don't have to, but it is beneficial. Also now, because we're filing in court the business is becoming a public record. A lot of when you file a petition for conservatorship and you're filing reports to the court, that information becomes a matter of public record. You know, not necessarily bank account numbers or anything like that. I'm not suggesting that, but your business kind of becomes more of a public record in how it's being handled. So more about conservatorship. When a court is looking at who to appoint as a conservator, they have a list of people of priority status as well. So they're going to be looking at spouses, parents, family members. You know, you might have had someone listed in a power of attorney, but now, you know, maybe that wasn't durable. So maybe they would look to that document for information on who might make a good conservator of your property. Let's see, and then always there are annual reporting requirements to the court. So again, just as there are reporting requirements for Social Security and so on, you do have to provide a report to the court. The difference here is that it's being filed into the court system and now is a record of the court, which is public. Again, account numbers are not, so there are some confidential filings, but the fact that you have a conservatorship and it's public record. And it's notable that conservatorship is one of the most restrictive measures that can be taken in regard to a person's personal life. So it should be approached with great care, and less restrictive options should be considered first. And then finally, we move on to guardianship. And we mentioned that conservatorship kind of manages property and funds for a person, and guardianship provides for the care of somebody who is unable to care for themselves. And the court may appoint a guardian if there's clear and convincing evidence that the person is incapacitated and that they require continuing care or supervision. And Nebraska law allows for and favors the appointment of what's called a limited guardian. And that's a guardian who looks out after a limited number of the person's personal needs. A limited guardianship is less restrictive than a full guardianship. And so we can kind of think back to the power of attorney document, where it could either be limited to certain types of actions or general, which applies to just about any kind of decision making that you could think of. The same is true here with guardianship, except again, we have court involvement, and we have, you know, filings that again are going to be public record about that the person needs a guardianship, usually reasons why they need a guardianship, and then, you know, annual reports are, you know, on the person's finances and, you know, their condition, how they're doing, where they're living, what kinds of services they're receiving, all of that kind of stuff. So generally, a guardian has the duty and responsibility to adequately take care of a person's well-being and personal needs. And these are the 9 areas that a guardian is responsible for in a full guardianship, but any of these 9 areas can be chosen as appropriate to identify a limited guardianship for someone. So the considerations are establishing a new legal residence for a person. They call that in the statute a place of abode. Arranging for a person's medical care, protecting the person's personal effects, so just, you know, their possessions, giving necessary consents, approvals, or releases on the person's behalf, so contracting essentially for the person, arranging for training, education, or other habilitating services appropriate for the person. So if they want to go to college, you know, you're helping to arrange for that. If they have accommodations they need in order to get their education, you're helping to arrange for that, or you're making decisions about it. It's not necessarily you who has to do all of this as a guardian. And then habilitating services. So for example, developmental disability services or habilitating services, or anything else that might help to mitigate a person's incapacities. And then applying for private or governmental benefits that the person might be entitled to, so Social Security, VA, state benefits, that kind of thing. Bringing actions against any individual whose duty it is to support the person if the person doesn't have a conservator. So not everyone who has a guardianship also has a conservatorship. So if there's no conservator involved, but maybe there's a situation you recognize might need legal action, it's the guardian's duty to go forward with that or explore what those options might be for the person. Entering into contract agreements for the person if they don't have a conservator. Receiving money and tangible property, having it go to the person and then applying money to the person's expenses, if there's no conservator appointed. And then the catch-all of any other relevant area, which I don't really know what that is. In fact, I don't remember ever seeing that identified specifically, as because there are lines for other to list, but I don't think I've ever seen that completed. So another important thing to keep in mind is that if the guardian, if it's limited where you are choosing where a person lives, or if it's full where that is one of your duties, that it's important to know that you can't change the location outside of the state of Nebraska or the county in which the guardianship originated without the court's permission. It's really more so outside of the state of Nebraska in practice than it is the county. But courts do need to be notified when a person changes counties, because that essentially changes the jurisdiction of the guardianship, because it's all county-based. Guardianships exist in county courts. Okay. So like other types of people who have decision-making authority, the court, again, looks to a list of people having priority status. So again, courts are looking at spouses, parents, siblings, other family members, friends, anybody who, might have priority to help the person, and Office of Public Guardian is way down at the bottom. Again, like conservatorships, there is annual reporting requirements to the court. Those, and I should mention too, conservatorship as well as guardianship, those reporting requirements, all conservators and guardians in Nebraska are trained on those by our office when they are appointed. So you'll take a training course that tells you how to complete those and what to be looking for and so on. And as I think I've mentioned before, guardianship is the most restrictive measure that can be taken in relation to an individual's personal life. So it should be approached with great care, and other least restrictive measures should be examined first.
We've had a couple questions come in.
Okay, sure.
First, is the age to file 18 or 19 for Nebraska for guardianship or?
Mm-hmm. In Nebraska, the age of majority is 19. So some people do, if they identify that guardianship is appropriate for their family, they will work with an attorney before the person turns 19 to file guardianship. If you're looking to protect somebody in terms of like medical care and so on, again, there's that surrogate option that could kind of fill the gap if the person turns 19 and you need to make medical decisions for them. That's available to fill the gap until the guardianship is actually in place. But in Nebraska, it is 19.
Okay. How do you notify the court of an out-of-state move?
Usually you have to get permission first before you move the ward out of state. So you have to motion the court to say, and again, you don't need, probably for that, you wouldn't necessarily need to access an attorney, but if an attorney is working for you, then they would file a motion to request permission to move the ward out of state. And I'm only speaking of adult guardianships here. So minors, I believe, would be a different story. But in fact, this whole presentation, I'm talking about adults. I should have prefaced it there. But so in terms of if you're not using an attorney, you know, you might be able to write a letter to say that I'm moving this, I would like to move this person out of state, or our whole family is moving, they live with us, blah, blah, blah.
We got a few more here.
Mm-hmm.
If we are looking at moving counties within Nebraska after my daughter graduates from high school, should I look at gaining guardianship after moving or before? She is currently 17, but will be 18 when we look at moving.
Now, again, in Nebraska, the age of majority is 19, so it probably wouldn't matter so much. But if you haven't initiated a guardianship and you're going to be moving counties, you would, no matter what, whenever you move counties, you're going to want to transfer the case to the new county through what's called a motion for intra-state transfer. And those, as long as the person is moving and they don't have any property in the past county, it's usually not an issue.
Okay. Can two separate individuals serve as joint guardians for somebody?
That depends on the county you live in. Some counties have decided that they don't want to have and that term is called co-guardians for a person. I believe Douglas County is a county that does not allow for co-guardians anymore, but other counties do allow that. And I think the reason that they don't is because I think they've run into issues maybe where the co-guardians don't agree on some things.
Okay, we've got a couple questions here regarding the initial process. How long does the process of guardianship take? Are there any fees for filing? And how far prior to my child's 19th birthday should we start working on the process?
It depends on how long it takes. Right now, courts are a little bit backed up, as you can imagine, because of COVID. So some hearings are able to happen telephonically to kind of keep things moving, but some, you know, because there are some that have to be in person. I would say from the date of filing, I would, again, depending on the county, smaller counties can move things through maybe a little bit faster. So I would say anywhere between 3 to 6 months. And yes, there are costs for filing. There are filing fees. We don't file petitions in our office, so I'm not really sure what those are exactly. I believe in total the court filing fees are under $100. But of course, when you're using an attorney, which again is helpful, it'll cost a little bit more. And you know, and it probably depends on the attorney as to what they charge for that. And so if you're interested in attorneys who would do that, it's a good idea to maybe talk to the Nebraska Bar Association or go to their website to find out which attorneys practice in probate and guardianships.
One more, who pays those attorney fees?
The person filing for guardianship can pay for those attorney fees. That would be called the petitioner. For cases that come to us, sometimes the ward is the one who's paying for those fees. It just kind of depends on the circumstances.
Okay, and just a comment here, if you have to use an attorney for each event, then being guardian could get quite costly.
It could, you know, again, you know, and it depends on what event we're talking about. So, you know, filing court forms every year is not something that requires an attorney. That's what we train private guardians and conservators for. And again, if you have questions while you're doing that process, you could reach out to our office and or the associate public guardians throughout the state, you know, depending on where you are, to help answer some of those kind of more technical questions. So I would say initially is probably where the most expense comes from with getting the guardianship in place with an attorney. But as the guardianship is ongoing, those are things that people can do on their own, you know, and unless something, you just have, you know, quite a few questions and really need some legal advice on something. Okay, the next thing I've listed that you can't even see here, but you can link to, is the flow chart of guardianship and conservatorships in Nebraska. So this kind of takes you through the process from beginning to end in a very summarized way, just with like filing the petition kind of in the first couple of boxes there, and then down to the middle two boxes have to do with like the initial court filings, and then later on are the annual filings and kind of the course that the guardianship takes from there. But it's a good overview to kind of see as a reminder what the process is. And I believe those, of course, blue items I think are hyperlinked to the forms, so that's helpful. Are there any more questions about surrogate decision making?
Not at this time.
Okay, great.
Not at this time.
Okay, thanks. So now we'll go into model practice in decision making. And the Office of Public Guardian, as I mentioned at the beginning, one of our duties is to demonstrate model practice in decision making. And the way that we do that and that we promote that is to make sure that we are making decisions with people that we are in charge of decision making for. So we're doing it with and for people. So one of those is called supported decision making, and this is a concept that is it's a newer concept in terminology, I guess. It was confirmed in the United Nations Convention on the Rights of Persons with Disabilities, Article 12. And in supported decision making, a person with a disability remains the decision maker with relationships and arrangements to help the person in making and communicating decisions about his or her life. And it maximizes their independence and promotes self-advocacy. And supported decision making is a process where individuals with an intellectual or developmental disability are assisted to make decisions for themselves. And it happens when an individual is the decision maker, but they get support from one or more persons who explain issues to them in a manner that they can understand. And there's not one model of supported decision making. So really, it's a term for a thing that everybody does every day of their lives anyway. So it's connecting people with other people that they can go to when they have certain decisions to make in their life. For example, I am not an expert on car repair, but my uncle is a mechanic. So when I need something, when I hear something going on with my car, but I'm not really sure it needs to be addressed, I'll, text him and see what he's got time for and get his expertise on what's going on, and from there I'll make a decision about whether or not it's worth fixing or putting off for a while or whatever the case may be. So again, that's just kind of a formalized term for what all of us do every day. We get the information we need by the people who can provide it to us so that we can make decisions. So what I described with supported decision making in Nebraska is not what's required by law, but it is what is model practice when thinking about how to work with someone to help them make decisions. Also not the legal standard in Nebraska, but a legal standard in some states is something called substituted judgment. And this is where we are substituting the judgment that the person would have used when they had capacity in the current situation. So it promotes an underlying value of self-determination and well-being of the person. However, it's not used when following the person's wishes would cause them substantial harm or when a guardian can't establish the person's goals and preferences even with support. So, you know, a person may have, let's say a person develops dementia later in life, or has a traumatic brain injury or something. And at one point in time, they would have decided that at one point in time they would have decided that they would want, let's say, CPR or something. They were adamant that that is something that they would want prior to all of this. But now, you know, they don't care. They're depressed. They don't even want to talk about it. There's just whatever, you know, just, and so when a guardian or somebody else who's in a position of making decisions for that person, what they do then is they think about, okay, so, you know, prior to, first of all, what kind of circumstances are we looking at here? Are we looking at this situation is never going to improve, this situation will improve, or in a short time it will, and then okay, this person always had, you know, prior to this accident or whatever, always had a very positive outlook on life and would have wanted to keep going under any circumstances. And so, okay, if I were to place myself in the shoes of that person, I think that we, at this point in time, I mean, they just recently had their accident. I think we want to just keep, you know, going forward. I don't think we would want to change their code status to the DNR right now. I mean, I think they're just experiencing maybe something that's a little bit shorter term for them. So it's keeping those values in place for that person. So maybe they're not in a spot where they can do supported decision making right then, because they are experiencing such a depression. But maybe they're in a spot where you could take what you know of them from before these circumstances and apply that right now in a substituted judgment format.
So we've had a comment and a question come in about the model practices. I really like this. It will help my adult child feel more, quote, normal about needing a bit of help. Is there something tactical we can do with these models of practices, or is it emerging and more for awareness?
I don't have those resources right here. I do know, and I also don't have them compiled at the ready, but I do know that if you Google supported decision making, those are things that, I mean, it is a term. There are lots of resources on what that looks like. I'm trying to think of person-centered planning materials are also a good place to look. Michael Small is a great resource of a person to Google. He has lots of actual tools of helping to make decisions with people. Like, I'm even thinking of a very simple one that has like a couple of columns of what's important to the person and what's important for the person. And so, like, under, you know, a certain circumstance, like, it's important, let's say a person wants to go to a party and they're not very experienced with going to parties, and maybe they have social anxiety. So but they like to be with people sometimes. So what's important to the person? Having a normal experience, being with people, getting to do things that their friends are doing. What's important for the person? Feeling like they're being supported while they're there, having somebody, just maybe one person that they know who's going to be there, who knows what they experience and that they can rely on, and maybe having their phone with them in case they feel like they need to leave or something like that. So using tools like that to help talk through some of those decisions with people is maybe a good way to help support their decision making and give them concrete ways to think through that process.
Looks like we have a question. Sorry, Michael, who?
Small, SMULL.
Thank you.
So then finally, and this is the legal standard in Nebraska, and it's the best interest standard. And I should have mentioned a long time ago that guardianship, the concept of guardianship is based in Old English law that was primarily originally interested in preserving property and money to pass on to future generations. So that being said, it's very paternalistic, and so is the best interest standard. So even though it's what's legally required in terms of practice for guardians in Nebraska, it's a last resort in terms of how you actually want to go about making decisions with people. Because what it is you're making decisions for people. However, that being said, you want to be considerate of again, what the person wants, what they value, and so on. But really, it's a last resort, as if you have no other, you're doing your best, you really don't know the person very well, and there's no way to get at this information. So, and I'm just going to go through the points that it's decision making that can be used when the person has never had capacity. When the person's goals and preferences can't be ascertained, even with support, or when following their wishes would cause substantial harm to the person. So, for example, let's say you are a guardian for someone who has a drug addiction, and their preferences would be to go blow all their money on drugs. Well, yes, but that would be very, very harmful to them, and unfortunately, that's the kind of decision that they would make, but as their guardian, you can't allow them to make that type of decision. So you're going to manage their money and opportunities for buying drugs to the extent that you can, and applying this best interest standard. So this principle requires that the guardian consider the least intrusive, most normalizing, and least restrictive course of action to provide for the needs for the person, and it requires the guardian to consider past practice and evaluate reliable evidence of likely choices. So the guardian should be cognizant of his or her own limitations or knowledge, and that's what's very important, is to make sure that really with all of these areas of decision making with the person, guardians need to be aware of their own biases and their own ways of thinking that influence a decision for this person. So in a best interest standard, we are often trying to keep somebody safe, and need to make sure that whatever preferences and choices that they're relating to us, we are definitely considering those and applying them to the extent that we can, that is going to also keep the person safe. All of those can be used in that way, but best interest is used when we really just don't have enough information, or the only information we're getting is something that would be detrimental to the person. So there's also a concept called intermittent incompetence. And so this is where, sometimes people have a cyclical impairment. So sometimes people who experience mental illness, for example, might cycle in and out of their ability to make good decisions that aren't harmful to themselves. So this is where neither model of guardianship, and we're talking about legal standards, which are best interest or substituted judgment, offer a satisfactory set of principles to guide the guardian. So best interest might not apply because an individual might have expressed wishes on numerous occasions, and substituted judgment might not wholly apply because an individual at times functionally, though not legally, can be competent. So the ethical principles favoring self-determination dictate that the wishes expressed by the person be adhered to if the person is in a lucid state, despite the judicial determination that the person is incompetent. So in other words, Again, always taking a person's wishes, values, and that sort of thing into consideration when you're making decisions with the person. When a person is demonstrating that they have more capacity and ability to think through and process certain decisions, recognizing that and giving it the what it's due, giving the weight to the person to make decisions about their life, rather than always applying the best interest standard just because that you're the guardian and that's what you're legally required to do. Always weigh how the person can participate to the extent that they can and what their wishes are, as long as whatever their wishes are isn't going to be harmful. So the Model Code of Ethics recognizes that there are these situations and reflects the conclusion that a guardian is obligated in limited situations to respect the wishes of the ward, even if contrary to the guardian's notion of best interest. And the Model Code of Ethics is based in part on the belief that self-determination and encouragement of growth of the ward through increased participation in decision-making whenever possible are ethically required. And this is information that comes from the National Guardianship Association, which I did not include that website, but that is a great website. They also have ongoing resources for guardians. They have a conference each year. Don't know about this year, but they ordinarily have a conference each year, and they publish lots of webinars and so on that are really good resources for folks. But they do have standards and model codes of ethics that they greatly adhere to. So again, making sure that we're recognizing that also we need to recognize that everyone makes mistakes, and we can't keep people safe all of the time. People learn from their mistakes as well. So if there are opportunities that present themselves where it's going to be a learning opportunity that's not detrimental to the person, then, of course, offer those for people so that they can be fully, experience their lives regardless of their disability and incapacity. So sometimes there are, even though we're making decisions with people, there needs to be a third-party review. So whenever possible, guardians should look to other people who might have expertise about a decision at hand. And in some situations, a guardian might be required, though, to request that the court weigh in on the issue. And this is an example about withholding food and hydration. In some situations, when we were talking about, sometimes there are family issues that come up for people where co-guardians, for example, why there aren't co-guardians in some situations is because sometimes one guardian will think that it's in this person's best interest to do this thing, and the other guardian might think, well, no, it's in their best interest to do that thing. And if they can't come to an agreement, then they may have to ask for a court hearing to have the court weigh in on something. Also, there are things that really guardians should be very leery of making decisions about on their own, and those have to do with things that remotely could look like they are impinging on somebody's constitutional rights. So when we're talking about for example, this is not a great example, but because it's rare, and I was actually shocked and appalled. But at one point in time in my career, I had a guardian contact me to ask me about sterilizing her son. And that is not something a guardian should just go ahead and do. First of all, the guardian should be consulting with experts or doctors about other less restrictive things. And from there, because we're talking about constitutional rights of being able to reproduce, that would probably need to have a court weigh in on that, and there would probably have to be expert testimony and so on. So there are just certain things that are very, very far down the line that guardians should be very reluctant to just kind of make decisions about when it comes to people's constitutional rights. Things to consider, of course, one of the biggest things is something called informed consent. With informed consent, you want to evaluate each requested decision. So in doing so, guardians will want to have a clear understanding of the issue for which informed consent is being sought, have a clear understanding of the options, expected outcomes, risks, and benefits for each alternative, determine conditions that necessitate treatment or action, encourage and support the person in understanding the facts and directing a decision, and maximize the participation of the person in making the decision. So this could definitely take the form of a medical context. For example, let's say a person is diagnosed with cancer, but it's treatable. And so, well, what kind of cancer are we talking about? And what kinds of treatment would need to happen? And, you know, what are the risks of those different kinds of treatment? And what are the benefits of it? And how long would it take? And, you know, and these are all, you know, again, ways, you know, doctors are going to speak in medical terms, and, you know, guardians will probably need to ask lots and lots of questions, and then make sure that the person is able to participate to the extent that they can. I mean, if you're not looking at an emergency situation, you've got some time to act and to talk about it, and you can start talking about it in terms that a person is able to understand. And in fact, it's the guardian's role, if the guardian isn't understanding what the doctor is saying, to ask more questions to get those terms broken down for the guardian. And then the guardian and, you know, their person can talk more about it, or maybe that person will be able to understand more themselves and be able to ask some questions. So again, it's gathering as much information as you possibly can from all of the sources that you can, so that you can weigh risks and benefits and determine what works best to move forward with and for the person. Other considerations, determine whether the person has previously stated preferences in regard to a decision of that nature. So again, did they used to have a power of attorney prior to the guardianship that might help inform what needs to happen here? Or if we're not even talking about a guardianship, do they have statements, you know, in advance directives or within their healthcare power of attorney that might offer that information? Determine why the decision needs to be made now rather than later. Determine what will happen if a decision is made to take no action. What's the least restrictive alternative for the situation? Do we need another opinion? All, you know, just all of those kinds of factors. I think there we go. And getting information from family, other professionals, and then asking for those recommendations to be in writing is something that we commonly practice at the Office of Public Guardian. We have I can't even recall what it's called right now, but it's a several-page document of just kind of a litany of questions that we tend to use when we are making complex medical decisions for people. And we try to get as much information that we can from doctors and so on in writing, and they're very reluctant to do that. But we want it because we want to have, I mean, of course we take notes, but we want to have good documentation in front of us to know what kind of decision we're making, and do we need to do this now? What are the options? We've sought second opinions, and you know, that's always a great idea. And that has been hard for some of the guardians to do because they don't want to offend the doctor who gave the first opinion, and that's been a growing opportunity for them to figure out, oh well, they are used to that. They, you know, they're not going to be offended, and if they are, we're not going to worry about it. We're going to move on and try to figure out what we need to figure out to make good decisions for people. Of course, there are exceptions to informed consent, but so of course, an emergency, sometimes there's just not time to gather all of the information, and you do the best you can with what you have. So again, hoping that even if you are working with a guardianship situation, or you're acting under other advanced directives, hopefully you've had some of those conversations about what a person would want in different circumstances, so that even in an emergency, you can make those decisions somewhat in confidence. But that is an exception to informed consent. Also, public health emergencies can impede on informed consent. Sometimes, I mean, as we all know now, to stop an infection, sometimes decisions need to be made that aren't going to gather informed consent. For example, we have several people who are older and are receiving care in nursing homes, and decisions have had to be made by the facility to move one person from one room to another because of, you know, they want to prevent the spread of infection, however it's working in that facility. So, you know, ordinarily we would have to provide consent when we talk with the person about, hey, is it okay if you move rooms? I mean, this is, you know, would you be living with someone else? Do you have your own room if you move? You know, those are all things that we would talk about with before we would consent to that. But in this kind of situation where there's a public health emergency, we don't have that luxury in certain circumstances. So that's just one exception. Once that's over, though, however, things will go back to having informed consent. It's not just a free-for-all forever. And then psychiatric treatment might also be an exception to informed consent. If there is evidence that the person is going to harm themselves or others, then there might need to be some kind of more immediate action taken to assist the person. So just a little bit more about capacity. As capacity increases with people, we want them to have more options to demonstrate their capabilities with that. So, you know, sometimes with children without disabilities, or, you know, without intellectual disabilities, we're able to just say, oh, you know, that's just part of growing up. They'll figure it out. They'll learn from that, blah, blah, blah. Well, you know, why can't we expect that from, you know, children even, you know, with intellectual disabilities? Again, give people opportunities to learn from life, so that they can build capacities, and then they will be more capable to make decisions for themselves in different circumstances. So with that, it's important to understand that capacity can fluctuate over time. Sometimes people lose capacity. That might be like a result of a head injury, or they have acute psychosis, or they're very depressed, that might subside later on, and they may then recover over time. People might develop dementia or Alzheimer's disease, but within that, they might have different levels of capacity. They might have certain times of day where they exhibit more capacity than others. There might be cognitive deficiencies that suggest incapacity are caused by treatable and reversible physical causes. Sometimes people are over-medicated, or they have had a toxic combination of medications. Sometimes their diet impacts their ability to function cognitively, or they have vitamin deficiencies, infectious diseases, poor eyesight even. I mean, maybe a new glasses prescription could help with some of this, or other conditions. And then discovering and addressing medically treatable conditions first may help with capacities being decreased, or not even, the person may not even appear to be incapacitated anymore once some things are taken care of. And so it's important to know that capacity is situational, and capacity assessment should never happen in a vacuum. People need to consider resources and support that are available to people. So again, I will go back to person-centered planning, and Michael Small is, again, a good resource to get started with. There are things where people can kind of look at what's their social capital. There's a diagram where you start with yourself in the middle, and then you have concentric circles outside of yourself. And so you list people who are the most important to you in that closest concentric circle. So often that will be, close friends and family, and maybe caregivers and so on. And then the more you move to outside circles, there are people who, are in your life, but they're not as important to you. And often the people who are on the more outside circles in our lives are the people who are paid to provide a service to us. So in my line of work with being in the different positions I've had, have noticed that when people with disabilities are younger, it's easier to identify some of those, have more people in that inner circle for them. But as people get older and they become less attached to people socially, for people who don't have disabilities who are paid, become more of that person's inner circle. And that's very sad. So as we're working with people, and if we want to build and sustain their capacities, we need to make sure that they're always maintaining those close, unpaid social connections of people who really are important to them throughout their life. And then, also we want people to have resources connected to them as well, so that they have the capacity to handle situations because they know which resources to consult with when they need them. But I really like that idea of the social and circles, and thinking about who do we have connections with, where can we build more connections, and that sort of thing. Capacity is contextual. It goes beyond the question of resources available to the individual, and considers how the individuals interact with those resources and with their social and physical environment. Undue influence, exploitation, or threat can directly affect the autonomy, functioning, and well-being of the person with diminished capacity. And a home environment that's familiar and comfortable for the person can enhance capacity, but a new and unfamiliar setting may undermine functional capacity. Last year with the flooding, we had a number of people who were displaced, and some of them had been, I don't think we had, in the area that it happened, we didn't have a lot of people who were in their own homes, but just even when they were in an assisted living facility, having to relocate to a temporary place and then relocate again to another facility that could care for them. That was very traumatizing for people, and especially if they experienced dementia. It was hard for them because it was unfamiliar, and maybe their staff wasn't there, maybe their friends that they'd made weren't there anymore. And again, going back to those social circles, when they didn't have a lot of connections, who were unpaid or just were together by circumstance in the first place, that can become very lonely and further diminish capacity. So again, making sure that those things that support a person's soul are in place, help them to build and even just maintain capacity when they're confronted with hard situations. It's important to remember that capacity is not all or nothing. We've moved away from an either or to a finely tuned functional definition. And a person may lack the capacity to handle financial affairs, but they can retain capacity to make healthcare decisions or to vote in elections. And so again, that's where it's important to really tailor decision making to what the person needs. Try to start with least restrictive options and think about how those might be able to work, or if they can't, and you absolutely have to go to guardianship, can the guardianship be limited? And if it can't be limited, okay, it's full, but how can I work with this person to help build capacity, maintain capacities that they already have, and really bring out the things that they do well so that they can continue to grow with those and recognize their gifts. So the term capacity is used in both clinical and legal settings. And in legal settings, a lawyer's assessment of a client's ability to conduct legal transactions is one way to look at capacity, and also a judicial determination of a person's legal abilities to make decisions or perform certain functions is a way to look at capacity. So a lawyer might be looking at whether or not a person has the capacity to create a power of attorney, for example. But also it's important to know that the way the lawyer talks about creating that document is important. So if a lawyer is talking in legalese about how to create that document, it's unlikely that a person would be able to show that they have capacity to understand what that means. But if a lawyer talks to the person about, when you go to the doctor, do you ever have a hard time understanding what the doctor is talking about? And, oh yeah, and, do you ever have anybody come with you to the doctor, because of that? Yeah, I like to have my mom come with me. Oh, okay. So if we were to take a piece of paper and write that your mom, is that you want your mom to come to doctor's appointments with you so that you can talk about what the doctor says and understand that together, is that something that you would like so that you can help, or your mom can help you make some decisions about your medical care? Oh yeah, that's more understandable than, oh, so you'll be the principal and your mom will be your agent and she'll be, making healthcare decisions for you about whether or not you want to receive CPR. I mean, no, there's a way to talk about complex issues with people in an understandable manner so that they can understand what they're doing, that they're creating something that where they're identifying somebody who's going to help them make decisions about something. And then judicial determination of a person's legal abilities to make decisions has to do with the evidence that judges see presented in front of them. So we mentioned with the guardianship, the clear and convincing evidence. So petitioners have to show, within those 9 areas of decision making that a person needs support in each of those 9 areas. And the court then has to find that, oh yes, that's 75% true, believable that is probably what the person needs, and I believe a full guardianship is warranted here, or only these types of decisions are the ones that the person needs help with, so we're going to limit it in that way. In clinical settings, it refers to a clinician's opinion of a person's abilities to make decisions or perform certain functions. And although a clinical capacity opinion is not a legal finding, it often serves as important evidence in legal proceedings. So again, I mentioned that that's what judges look at. So when we have people who we think are, we're really kind of questioning why they have a guardianship, because they seem to know what they're doing. They seem to be able to make decisions and understand what the effects of those decisions would be. We have worked sometimes with people to go get a psychological evaluation and get a medical opinion about whether or not they still need to have the guardianship. And in some circumstances, they have been told, no, you don't need a guardian. You can make decisions in these areas and you understand the consequences. And we've been able to have some of our guardianships removed in that regard. So, you know, again, that's again where it's important to recognize when a person has built their capacity, and then to, you know, seek medical opinions to support that so that a person can exercise as much autonomy as possible. And I kind of just talked about this, where limited guardianships are an option for judges to craft orders to match the functional strengths of the individual, and how that helps to promote autonomy. And then clinical, and then the next couple of slides, and I know I'm running out of time here, but clinical evaluations can be very complex and have a great opportunity to provide really good information. Unfortunately, what we see are a lot of substandard clinical evaluations that, especially when it comes to putting guardianships into place for people, we have seen like one-page letters from clinicians about, well, this person just, they just don't make good decisions and they need a guardianship, the end. And that's not just limited to Nebraska. There's further information on this slide about how clinical reports for guardianships of older adults range between 83 words in Massachusetts, with 2/3 of those illegible apparently, and 781 words in Colorado, which is 1 to 3 pages, compared to 24 pages, which is the average length of child custody evaluations. So it becomes very, for some reason, the practice is that it's a lot easier to put a guardianship on someone, here anyway, than it is to have a guardianship terminated. So when we recognize that a ward has really built their capacities, we make sure they have a good evaluation to present to the court. So there are 6 key domains of a good capacity assessment that is consistent in both legal and clinical sources, where they address the medical diagnosis of the person, their cognitive ability, their everyday function, their values and preferences, their level of risk and supervision needed, and their means to enhance capacity. And there are publications that are joint publications from the American Psychological Association and the American Bar Association that have created these, that they've identified as the 6 pillars of capacity assessment. And if you ever want to nerd out and look that up, it's very interesting to know how comprehensive really assessments should be when we're talking about you know, removing people's autonomy. Finally, I feel like I have thrown a lot of information, but are there any more questions? I've really appreciated the questions, Jennifer, that you've put forth so far. So if anybody has any more, I'm happy to answer those.
A comment came in. I participated in a webinar in March called Empowering Adults Through Supported Decision Making, the Role of Families, Guardians, and Caregivers and Others in Supporting Individuals Receiving Home and Community-Based Services, put on the Administration for Community Living. And they may have more coming up, just some information there. And then somebody just wanted to say thank you very much. It was a very helpful presentation.
Well, thank you. And I do know that the Association of Community Living does put out really good resources. So thank you to whoever put that forward. That's a great thing to look up for a lot of good leads on other resources as well. So thank you. And thank you for having me. I enjoy doing this. I love the in-person ones as well. But I believe on the last slide, I think there's my contact information. I think it's actually our general office information, but if you want to reach out to me individually, Rhonda has that, and I'm I'm happy to connect with you individually as well. So thank you.
Thank you for joining us tonight, Marla. I did want to just mention, if you have any other additional comments, you'll have a moment here quick in just a second to conduct the poll. But if you have any other suggestions, please feel free to give me send me an email. Just if there's anything more elaborate that you want to kind of go into, that we would love to hear from you. And know if this has been helpful, and if there's anything that you would like to see more of, or how we can maybe change things up a little bit. So with that, I will go ahead and put the poll up just for kind of as a survey. And then, you know, if you wouldn't mind taking a moment, I'll leave that up for about 5 minutes or so. So thank you all for joining us. Thank you, Marla. We really appreciate having you. Always great to get that information from you.
Thank you very much.